Okay, hi, Assalamualaikum. My name is Nur Syafiana Nabila binti Wazi, and also my key matrix is D19312086. I also the group leader for group 7, and today we will discuss about chapter 8, so let me start first. Alright, in this case we will discuss the ethical challenge involved in employee migraine labeled across a number of regional contexts. It provides an insight into the vulnerabilities of migrant workers and the poor working conditions that they often encounter, sometimes giving rise to slave-like conditions. The case provides an opportunity to examine the issue of employee rights discussed in Chapter 8, as well as offering a deeper look at the conditions giving rise to violations of these rights. Alright, introduction of employees as stakeholders. Dealing with employees is probably the area where all of us at some stage are most likely to encounter ethical issues and dilemmas. Whether it is a question of fair wages and conditions, sexual harassment in the workplace, or simply taking advantage of company resource for personal use, employee-related ethical problems are unavoidable for most contemporary manage. On a smaller scale, the political agendas of traditional labor, socialist or social democratic parties will target at changing legislation, implementing a so-called welfare state, and providing the masses with an entitlement to decent working conditions. By the end of the last century, however, with socialism and communism in retreat, and even most left-wing governments under heavy budget pressures to cut back on the welfare state and reduce regulation, ethical issues in employment had gained their position on the business ethics agenda. MNCs from the global north are confronted with issues such as the protection of organs, human rights in their factions in Bangladesh, China, or Cambodia, while in their own countries a variety of different ethical questions for MNCs arise from the usage of new technologies such as the internet and the introduction of new environments such as call centers. Are employees as stakeholders? Like shareholders, employees take on peculiar role among stakeholders as they are closely integrated into the firm, whereas shareholders basically own a share of the corporation. Employees actually constitute the firm. They are perhaps the most important production factor on resource of the corporation. They represent the company towards most other stakeholders and act in the name of the corporation towards them. This essential contribution, as well as the fact that employees benefits from the existence of the employees and are quite clearly affected by the success or otherwise of their company, and widely regarded as giving employees some kind of definite stake in the organization. Right, on the legal level, this is normally some sort of contract between the corporation that stipulates the rights and duties of the two parties. This legal relationship, furthermore, is quite strongly embedded in a rather dense network of legislation that provides a legally codified solution to a large number of issues between companies and employees, such as minimum wage, working conditions, and due process. Although there are certainly, to a varying degree, a fair number of legal rules pertinent to all other stakeholders' relationships. The relation between corporations and employees is peculiar in that it has traditionally been the subject of governmental regulation in most countries from the very beginning of the Industrial Revolution onwards. This characteristic has strong implications also for the economic aspect of firm-stakeholder relationships. The relationship between firms and employees is characterized by certain externalities on both sides, by which we mean that there are costs to each that are not included in the employment contract. Examples from the perspective of the employee include investing in a new job by moving to a new town, which might involve things like leaving behind friends and family, finding new schools for your children, and others. As a result, it is often the place where friends and social relationships are met and where the human needs for self-actualization is met. All of this results in a considerable amount of dependence from an employee on their employee. Alright, that's all from me about introductions of employees as stakeholders, and I will pass it to my teams.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Iqmal Hakim bin Abdul Hamid, and I want to talk about management of human resource and ethical problem between rights and duties. Employees are in principle managed by the Human Resource Department, a term which already indicates a first problem from an ethical perspective, as it is the term human resource management and its implications have been the subject of some debate in business ethics. Hart 1993, Torrington 1999, Barrett 1999, Greenwood 2002. If we recall Kantian theory, the second maxim requires us to treat humanity always as an end and never as a means only. Human resource, however, does exactly this. We as humans are constituted as an important resource, and in most cases, most costly resource as well. Consequently, employees are subject to a strict managerial rationale of minimizing costs and maximizing the efficiency of the resource. In fact, one could argue that the core ethical dilemma in human resource lies in the fact that people in the firm under economical criteria are nothing more than a resource next to often competes with other resources, most notably new technology or cheaper resources from overseas. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Iqmal Hakim bin Abdul Hamid, and I'm from Group 7. I want to explain about discrimination, harassment and discrimination in workplace. Harassment and discrimination are arguably the largest ethical issues that impact business owners today. Should harassment or discrimination take place in the workplace, the result could be catastrophic for your organization for both financially and reputationally. Every business needs to be aware of anti-discrimination laws and regulations that exist to protect employees from unjust treatment. The U.S. Equal Employment Opportunity Commission (EEOC) defines many different types of discrimination and harassment status that can have an effect on your organization, including but not limited to its age. It applies to those 14 and older and to any ages, policies, or treatment that take place. Next, disability is accommodation and equal treatment provided within reason for employees with physical or mental disability. Equal pay. It means compensation for equal work regardless of sex, race, religion. Example, pregnancy is accommodation and equal treatment provided within reason for pregnant employees. Therefore, race employee treatment consistent regardless of race or ethnicity. Next, religion is accommodations and equal treatment provided within reason regardless of employee religion. Lastly, sex and gender employee treatment consistent regardless of sex of gender identity. Sexual harassment. More often than not, when we discuss harassment at work, the topic quickly shifts to sexual harassment. There's no doubt that it is an ethical issue in business that should be taken very, very seriously, where we should not forget that there are many forms of harassment in the workplace. Sexual harassment is one that deserves to be addressed on its own. What can your business do about sexual harassment? The most important step in addressing sexual harassment as a serious ethical dilemma in business is to implement employee training. Start by making sure everybody who works for you is made aware of the rules. That those rules are posted around the workplace, and by enforcing a zero tolerance policy for sexual harassment. From there, you want to ensure that leaders in your business are setting good example, that you continuously monitor for inappropriate behavior, and that you provide employee with a safe and discreet avenue for reporting case of harassment. Employee privacy. The fundamental right to privacy consists of an individual entitlement to control information about themselves and to control situations where such information could be gleaned. According to Michael Sims, 1994, there are 4 different types of privacy that we might want to protect. Is physical privacy. Physical inaccessibility to others and the right to one's own space. For example, organization, the place surveillance camera and in employees. Private rest area might be said to compromise physical privacy. Secondly, social privacy, freedom to behave in our private life in whichever way we choose. For instance, some employers will threaten social privacy by suggesting that employees should not bring their firm into into dispute by behaving in an unacceptable, immoral, or illegal way during their social life. Next, informational privacy means determining how, when, and to what extent private data about us are released to others. This can be breached, for example, when employers hire private security firms to investigate employees without due cause, or when employees' social media use outside the workplace is monitored by their employees and physical privacy. It controlling emotional and cognitive inputs and outputs and not being compelled to share private thoughts and feelings. For instance, uh, psychological privacy is threatened when retailers introduce programs aimed
Health and drug testing. Health and drug testing is quite a contested issue in business ethics. The central objective is that such tests make available far more information on the employee than the employer actually needs. There are only a few jobs where information on health and drug use is really vitally important for the safety of the job or for the protection of customers. And its test might conceivably make sense for a nurse or a chef, but it is certainly not an issue for a software specialist or a lorry driver. Next, causes of employees' performance. Employers are well within their rights to determine whether their employees are performing at a satisfactory level and to take action if they are not. However, the employer does not necessarily have a right to know about all of the personal factors influencing the employee's performance. Suppose we are depressed or suffering from bereavement or have just stayed up drinking too much the night before. This may affect our performance, but then again it may not. It would be quite difficult to accept that we should reveal this information on arriving at the office in the morning unless there is a clear ongoing problem with our performance. Indeed, it has been shown that many employer-related factors are likely to have a greater impact on performance than drug and alcohol use, including bad working conditions, excessive workloads, and work-related stress. Lastly, level of performance. These Jardines and Duska further claim that an employer is only entitled to an acceptable level of performance from their employees, not their optimal performance. Most drug, alcohol, and health tests aim to identify factors that potentially might prevent the employee from functioning in the most optimal fashion. Again, the key issue is whether we are performing at an acceptable level in the first place, nor whether we could be made the performance better. Next, employee participation and association. Financial participation allows employees a share in the ownership or income of the corporation. Initiatives predicated on partly remunerating executives with stocks or stock options in order to align incentives with shareholders. Operational participation occurs at a more practical level and can include a number of different dimensions. Is delegation. Employees can be delegated control over a range of decisions relevant to their jobs. Efforts of this kind have often been labeled as job enrichment or job enlargement schemes and have been practiced successfully, for instance in the automotive industry. Next, information. Employees can also participate by receiving information about crucial decisions that have an effect on their work. This especially concerns information about the performance of the corporation, the security of jobs and pensions, and other. In addition, consultation. Okay, in some contexts, employees may have the opportunity to express their views on potential decisions planned by the employer. This form of participation is stronger still since it opens up the opportunity to actually influence the decision taken by the employer. Lastly, co-determination. Here, employees have a full and codified right to determine major decisions in the company. This is the strongest form of participation and would include decisions about the strategic future of the corporation, such as mergers or diversification into new markets. Freedom of conscience and freedom of speech in the workplace. Normally, the right to freedom of conscience and speech is guaranteed by governments, and so individuals can usually count on the government to protect these rights. However, within the boundaries of the firm, there might also occur situations where these rights, especially the freedom of speech, might face certain restrictions. This is the case with regard to, for example, speaking about confidential matters regarding to the firm's R&D, marketing, or accounting plans that might be of interest for competitors, shareholders, or other stakeholders. However, there are some cases where such restrictions could be regarded as a restriction of employees' rights. Imagine, for example, that a manager asks you to take part in activities that are of contestable moral status, such as some creative accounting for the organization. The problem for you is that you cannot ask third parties outside of the organization for help in this situation without risking serious embarrassment, disrepute, and even possible financial harm to your company. As we said in Chapter 4, if employees decided to inform third parties about alleged malpractice within the firm, this behavior is normally called whistleblowing. The main problem for employees with whistleblowing is the fact that it involves a considerable risk for them. Okay, lastly is the right to work. Established in the Declaration of Human Rights and more recently in the European Charter of Human Rights, The right to work has been codified as a fundamental entitlement of human beings. As such, the right to work is derived from other basic human rights, namely, it is linked to the right to life, since work normally provides the basis for subsistence, and it reflects the right to human respect, as the ability to create goods and services by working represents a major source for self-respect for human beings. On a macroeconomic level, one might argue that governments have the responsibility to create economic conditions that protect the right of every citizen to work. Employing and paying people a salary is only possible if the company is able to sell a reasonable amount of goods and services. If this condition is not fulfilled, a one-sided focus on the right to work would clearly violate the right to own property and the right to free engagement in markets. Therefore, the right to work in a business context cannot mean that every individual has a right to be employed.
Assalamualaikum warahmatullahi wabarakatuh. Today I will present about the ethical challenge of the globalization. Okay, first, globalization of business practices has had a significant impact on the question of the ethical treatment of employees. Second, issues that relate with the workers such as discrimination, fair treatment, acceptable working condition, fair wages, and necessities for freedom of speech are interpreted and made meaningful in different ways in different cultures. Okay, for example, a conception of racial, sexual, or religion discrimination in Ireland might be different from Indonesia or Italy. Okay, similarly, freedom of speech might be conceived differently in Mexico than Myanmar. Okay, next I will tell you there is three of the underlying issues that involve here. Alright, we move to the first issue, which is national culture and moral values. Okay, according to the Horsfit model with 5 dimensions characterizing different culture values: first, individualism or collectivism; second, power distance; third, masculinity or femininity; fourth, uncertainty avoidance; fifth, long-term or short-term orientation. Alright, this dimension focus on some of the key aspects underpinning the moral values that govern employer-employee relations. Right. For example, dimension of individualism or collectivism, which present the degree to which people think of themselves as the independent autonomous actors or acting for the good of the group. Alright, individualist cultures will tend to regard it as more acceptable for each worker to be individually responsible to their employers, whereas collectivist cultures will tend to emphasize the necessities of associations and collective participation. Similarly, in collective societies, a person's ability to work well with others and make collaborative decisions might be just as much prized as educational and professional qualifications. Here is that different culture will view employee rights and responsibility differently. This means that managers dealing with employees overseas or even critics of the business who look to business practices overseas need to understand the culture basis of morality in that country. Alright, for example, do Indonesians employees not have the same needs for health protection as workers in London? Okay, this raises the problem of relativism versus absolutism. Okay, now we talk about absolutism versus relativism. Alright, absolutism represents ideas that if an ethical principle were to be considered valid, it had to be applicable anywhere. Relativism suggests that no one view of ethics can be said to be right, since it must always be relative to the historical, social, and cultural context. Relativists would finish argument quite easily by dismissing the necessity for moral judgment from the West about foreign culture context, while absolutists say if our moral standards are right, they are right everywhere around the globe. Alright, relativism ultimately will deny any ethical problems around exploitation and poor working conditions as long as such conditions comply with the standards of the respective country or culture. Okay, in the context of absolutists, companies should respect employee rights equally, where it is that they are actually contract work. Obviously, these two sides are never likely to reach a common decision. Beyond consideration of human rights, ethical considerations occur around the fact that differences in the treatment of employees on a global scale are not necessarily ethically wrong per se, but depend on the relative economic development of the country in which the practice is taking place. For example, one could argue that today's Pakistan is at a stage of economic development similar to many European countries just after the end of the World War II. Therefore, it is ethically fair to have longer working hours in today Pakistan, since back in 1950s and 1960s, most European countries will still have a 48-hour week. Okay, now we move to the second issue, which is the race to the bottom. Okay, the race to the bottom first. Globalization clearly enables corporations to have fairly broad range of choice for the allocation of plans and office. This means that when you pick up the phone in Malaysia, and dial the customer service department of your bank, you could just as well to be connected to an operative in overseas, which is like Indonesia and Singapore or else. Consequently, developing countries compete against each other to attract the foreign investment represented by such relocation decisions. Okay, second, large investor may well choose the country that most preferable conditions, which means that the lowest of regulation and social provision for employees. This competition therefore can lead to a downward spiral and our protection, or what is often called race to the bottom in environmental of social standards, according to Rudra 2008. Third, countries do indeed compete on the basis of reduced labor market standards to attract foreign direct investment. Not surprisingly though, it has also been hotly contested, not least because of the political and ethical ramifications of such an argument. Alright, fourth, rather than being concerned with ethical standards solely within the premise of their own company, MNCs, as perhaps the most powerful actors in such countries, are also in a position to assume a key role in building up so-called background institutions. This includes institutions such as trade unions, health and safety standards, and various other rules, regulations, and standards that help to protect workers' rights. For instance, contends the MNEs have a duty to avoid causing harm, and that this carries with it a responsibility to promote minimally just social and political institutions in countries in which they operate, should such institutions be lacking. Okay, now we move to migrant labor and illegal immigration. First, phenomenon of globalization has been growing mobility of workers globally, and this can typically occur in the form of south to north immigration, such as influx of immigrants from Latin America to the US, or from Africa into the European Union. but it is also occurs in many other regions globally, such as in Southern Africa or the United Arab Emirates, the latter drawing a large workforce from Pakistan, India and Bangladesh. Okay, second, migrant labor can also be a phenomenon attracted by certain industries, such as the mining industry, which often operates in geographic location where there is no immediate workforce to recruit. Third, migrant labor often puts corporations in a position to provide a host of social infrastructure, such as housing, transport, healthcare, or education in place. Okay, fourth, many migrant workers often come from poor countries. They are frequently willing to accept working conditions and salary levels that would normally be considered unacceptable. This is a key issue, however, is that these workers often enter countries illegally. In many places, it is against the law to employ migrant workers. However, much businesses or even whole sectors may rely on such a pool of workers. All these factors make immigrant workers particularly vulnerable to exploitation, and it's no surprise to learn that migrant laborers often end up in working conditions akin to modern-day slavery.
Hi, my name is Nur Husna binti Ulul Azmi. My matric number is T19312069. I will talk about the corporate citizen and employer relations. As we have discussed in some detail early in the chapter, ethical issues in employer relations are primarily framed in terms of a collection of rights. As such, the issue have a close relationship to the notion of corporate citizenship. Corporations govern a great deal of the social and civil rights of citizens via the workplace. They need to protect privacy of information, provide human working conditions, ensure fair wages, and allocate sufficient pensions and health benefits. A first aspect here is how far different legal and governance system in various countries push companies to respect the rights to their employers. The key concept in this context is the idea of co-determination, which describes the relationship between labor employers and capital shareholders. Beyond the developed world context, it is fair to argue that generally the level of regulation, or at least enforcement of regulation protecting employers, is rather low in developing countries. Hence, many of the issues discussed here fall into the realm of voluntary good citizenship from the corporation, which, as we discussed in Chapter 2, often assigns to companies a role in respecting, protecting, and implementing basic human rights in the workplace. That said, however, we see that in many emerging economies, governmental have over time tended to strengthen the protection and implementation of employers' legal rights. Managing international human rights. What are human rights? Human rights are basic rights that allow individuals the freedom to lead a dignified life, free from fear or want, and free to express independent beliefs. These rights apply equally and universal in all countries. In 2008, John Ruggie developed a framework of understanding business responsibility in the area of human rights. This framework of protects, respect, and remedy offers an important starting point for delineating corporate and governmental responsibilities in this conversational area. Protect. Under international law, states have a duty to protect against human rights abuse by non-state actors, such as corporations. This might be when such abuse have affected people within the state's jurisdiction, or in some circumstances when the corporation is within the jurisdiction of the state, even if the abuse happens overseas. Respect. Corporations have a responsibility to respect human rights in that they are expected to obey laws on human rights even if these are not enforced, and should respect the relevant international principle of human rights even if national law is absent. Firms are therefore required to undertake due diligence in identify areas where there are potential threats to human rights and managing these risks accordingly with tools such as impact assessments and performance tracking. Remedy. Finally, given that disputes over human rights impact are inevitable, firms and governments need to put in place formal grievance procedures and systems for investigation and punishment of abuse. That's all from me. Thank you.
Assalamualaikum, nama saya Nur Fatin Syazwani binti Muhammad Zahar, nombor matrik di 193-11729. Towards Sustainable Employment. In this chapter, we have talked a great deal about respecting and guaranteeing employee rights in the workplace. Sometimes protecting of wage and condition for workers may have to be clarified to encourage sustainable economic development and maintain employment. Expansion of environmentality damaging industries such as the airline industry can often be seen to be good for job creation. Looking at it this way, there usually have to be some clarify or trade-off between protecting employees and promoting various aspects of sustainability. On the other hand, it is also possible to reason certain links with the intention to protect employee rights and the notion of sustainability. If we are gainfully employed in useful work and feel respected as human beings, a workplace that puts us under stress or where we are treated unfairly will have long-term effect on our lifestyle, health and well-being. This aspect is closely linked to the social dimension of sustainability. Organizations should treat the community of workers in a way that stabilizes social relationship and supports employees to maintain meaningful social relationship with their family, neighbors and friends. Finally, sustainability is also an issue here in the ecological sense. The modern corporation has in many ways created workplaces that are ecologically unsustainable. In this section, we shall look at three main ways in which these problems and tension have been addressed both in theory and practice. Rehumanized workplace, wider employment, and green job. Rehumanized workplace. The alienation of individual worker in the era industrialized mass production has been discussed at least since the time of Karl Marx. The suggestion is that impact of technology, rationalized work processes and the division of labor has meant that many employees simply repeat the same monotonous and stupefying action over and over again, resulting in there being little real meaning, satisfaction, involvement in their work. The relationship between technology and the quality of working life is, however, actually a complex one. The impact on the workplace are at the very least contingent on a variety of factors, including work's organization, managerial motivation, employee involvement. The point is that meaningful work is clearly not available to all, representing other forms of injustice that we need to be aware of beyond simple distribution of benefits. There have been numerous attempts over the years to rehumanize the workplace in some way, from example by empowering the employee. They might include job enlargement, giving employee a wider range of tasks to do, and job enrichment, giving employee a large scope for deciding how to organize their work. Some car manufacturers, most notably the Swedish firms Saab and Volvo, have experimented with replacing their production lines with small, partly autonomous, team-based working groups. Next is wider employment. The mechanization of work has led to the situation where a large proportion of unemployed people has become a normality in many countries, threatening not only the right to work but the social fabric communities. Actors such as Jeremy Rifkin have even gone so far as to suggest that new technologies herald the end of work. Modern employment patterns have tended to create a cleavage between those who have the highly skilled job and require long hours of work for high returns and those who are reduced to unemployment or the best a succession of low skill, poorly paid, and temporary jobs. The debate got a new boost with the concept of the 21-hour week, developed by the UK-based think tank, the New Economics Foundation. It proposes a radical new approach to distributing work in society and suggests a model where everyone works just 21 hours a week. The core argument is that just a reduction of the core working time will not just distribute work more equally, and most importantly, it will free up people's life to pursue other currently neglected tasks such as preparing more of one's own food, caring for children and the elderly, more time for civic engagement. Green jobs. One aspect of this green job is, of course, that there are in industry producing environmentally friendly products such as recycling and car sharing. Another aspect of this movement towards green job is that the job itself, the workplace, the way labor organized become more environmentally sustainable. Apart from social benefits for the employee that teleworking can potentially bring, there may also be economic benefits for the company and even ecological advantage too. For instance, rather than commuting into work and adding to road congestion and air pollution, teleworkers are likely to use far fewer resources by staying at home and commuting remotely. Lastly is summary. In this chapter, we have discussed the specific stake that employees hold in their organization. It suggested that although the stake is partially regulated by the employment contract, employees are also exposed to further moral hazards as a result of the employee-employer relationship. Nearly the entire spectrum of human rights is touched upon by the modern corporation, including issues of discrimination, privacy, fair wage, working condition, participation, association, due process, and freedom of speech. In that, we explain that governmental role in issuing legislation of protect employees' rights has to some extent retacted. We also explain how corporations in different parts of the globe face different regulatory environmental, making it sometimes easier, sometimes more difficult to live up ethical obligation towards employees. We also explore how the corporate role in relation to employees quite often puts corporation in a position very similar to the occupied by government in relation to their citizens.